On behalf of the board and the officers of IPLAC, we welcome you to this very special event. My name is Adam Kelly. I'm the president of IPLAC. I'm honored to be the 134th president of IPLAC. We're the oldest IP bar association in the United States. We have over 800 active members, 25 standing committees. If you're not a member of IPLAC, we encourage you to join to not only come to exciting events like this, but those that we have throughout the year. And with that, I'll turn it over to our corporate committee, and thank you for our corporate committee for putting on this special event. Thank you.
Okay, thank you, Adam. So I have just a few brief comments before we start with what everyone is here to see today. My name is Gavin OKeefe. I'm a partner at McDonald, Bain, Holbert & Berghoff, probably better known as MBHB, which, as Adam mentioned, together with the IPLAC Corporate Committee, is putting on today's event. So I'd like to start by saying thank you to Chicago Kent for offering this space. Looks like we've got a really nice turnout, so we're certainly making use of it. Personally, I'm really happy to have this event here. I have a lot of ties to Chicago Kent. Not only did I graduate here, but I have two siblings, an uncle, and a grandfather who all graduated from here as well. So we got 5 total in my family. I'm also an adjunct professor here. I teach a class called Strategies in Intellectual Property, so I still get to spend quite a bit of time at the school. I'd also like to say thank you to everybody who helped plan this event. We had a lot of people who put in a lot of time and effort, including Billy Hinnon, other members of the IPLAC Corporate Committee, a number of partners at MBHB, along with people at the director's office and here at Chicago Kent. So thanks to everybody across the board. So with that, I'd like to introduce our 2 guests this morning. The first, sitting closest to me, is Grant Drutchas, managing partner of MBHB, who will be hosting today's fireside chat with our second guest, who I'll be introducing in just a moment. Grant has more than 25 years' experience in patent and trade secret litigation and licensing. He is the co-chair of MBHB's litigation and PTAB trials practice groups, and he is the vice chair of IPO's Biotech and Pharma Issues Committee. Grant is also an adjunct professor here at Chicago Kent. He teaches a IP licensing and valuation course. And as a side note, I can say that I know he's been doing that for a long time because I actually had Grant as an adjunct professor almost 15 years ago when I was a student here. Sorry, Grant. Next, it's my great privilege to introduce and tell you about the Undersecretary of Commerce for Intellectual Property and Director of the U.S. Patent and Trademark Office, Andrei Iancu. Before he assumed this role, Director Iancu was the managing partner at Irell and Manella, LLP. He also practiced full-time as a member of the litigation and intellectual property practice groups. In that role, he was also involved in all other aspects of intellectual property practice, including prosecution, due diligence, and licensing. He's represented a number of clients across the technology spectrum, including those associated with medical devices, genetic testing, the internet, television broadcasting, video game systems, and computer peripherals, just to name a few. And in addition to his practice, Director Iancu taught patent law at the UCLA School of Law. So with that, ladies and gentlemen, please join me in welcoming both Grant Drutchas and USPTO Director Andrei Iancu.
Thanks, Gavin. Good morning, Director.
Good morning. Good to be here.
You know, a couple of years ago, you were a successful litigator, a managing partner of a leading law firm in the United States, very well respected, and yet you made the decision to become the PTO director, all during a time when PTO was fighting for funding from Congress, and frankly, patents seem under attack from Congress, the Supreme Court, sometimes even the executive on the pharma side, and in some ways the public itself. What were you thinking?
Well, you're a managing partner of a law firm. Wouldn't you rather do something else?
You do have a point. Retirement sounds better than any of that.
Yeah, look, for a lot of the reasons that you have mentioned, I wanted to get in and try to make a bit of a difference if possible. The IP system, which we all love quite a bit, especially on the patent side, has been pushed and pulled, and as you've indicated, significant issues that have developed at least over the past, let's say, decade, maybe even more. So instead of just talking about it, I thought I could throw my hat in the ring and try to do something about it.
You know, it appears that several interest groups have kind of hijacked in some ways some of the conversation on patents. And it has been responsible for a lot of the public discourse over patents over the last couple of decades. And to some extent, the Supreme Court and Congress have paid attention to that public discourse. You know, what role can the executive branch and the PTO in particular play in connection with dealing with that public discourse?
So I think you've touched on one of the most important issues that I think have been hanging over the patent system, and in my view, influenced the patent policy of the United States in the wrong direction, and that is the public discourse. Because before we talk about public policy, IP policy, before we talk about implementing new laws, administering new laws, and so on, before all that is the public discussion that takes place that drives all these various actions. So if the public discourse is focused almost entirely on faults in the system, the negative aspects of any system, then obviously the public policy that flows from that will be aimed almost entirely at addressing, the perceived faults in the system, as opposed to what I think would be better, to have a positive dialogue about our system. There is so many positive stories to tell about our patent system and the incredible benefits it has brought to this country over the past, since our founding, that you begin from there, you drive public policy from that aspect, and you strengthen the system. How do we make it better? How do we harness all the incredible achievements to date and do more of it, or even better than that? Of course, that doesn't mean you don't address the faults in the system. You have to address the faults in the system and do it swiftly and efficiently. But you cannot have, if you want to have a successful system, you can't have it driven entirely by a discussion about the faults in the system. So to your last point, what can the PTO do about it, or the administration as a whole, is to drive that positive dialogue, and we are doing that. I certainly do it on a consistent basis. It is part of the actual agenda to change the dialogue. But you see my boss, Secretary Ross, doing it. He speaks when he has a chance to speak about IP. He speaks positively about it and the importance in the system. The president does it, talks about the importance of IP. We live in an age when IP is really important, so we need to focus on how we use it to our greatest benefit.
The ABA, AIPLA, and IPO have offered some proposed legislation revisions to Section 101. There's some other proposals with respect to other aspects of the the patent statute that are being proposed currently in Congress. Can the PTO take any positions on any of those statutes or bills?
So as a general principle, yeah, the PTO can and does often take positions on IP legislation. And in fact, when there is concrete legislation, we almost always take positions on that. And sometimes we drive the discussion. Specifically on 101, and I'm sure we're going to get a bit more into it, but specifically on 101, there is no legislation right now that's being introduced. It's being contemplated. But when there is something more concrete, we probably will address that. We'll take a look at that and get a bit more into it. We obviously on 101, our focus right now, we have focused for the past year, and we're going to keep focusing on it this year from the administration point of view. which is how are we administering the current law, which is a big job in and of itself. In fact, it's one of the most important things going on in patent law right now. How do we administer the current law? Take the state of the law as we have it. We have, 650,000 applications we have to process every year, and hundreds or thousands of appeals at the PTAB and so on, that we must deal with it now. So we're quite busy doing that. Of course, when we see legislation, we'll deal with that as well.
With respect to administering it, obviously the PTO recently released the 101 guidance, January 7th, I think it was. And one of the concerns that has been expressed is the extent to which some aspects of it, particularly the practical application component, is completely consonant with Supreme Court case law. Do you have any thoughts about that?
Yeah, sure. I mean, this is it's a huge topic, and as I said, I think this is right now the most important substantive issue in patent law. First of all, everybody here is a patent lawyer. Who is not? Okay, so there are a few. Well, so let me just back up a little bit then, since there are a few. So, Section 101 of patent law of the Patent Code, which is patentable subject matter, deals with the categories of subject matter that the United States is willing to give patents on. Okay, and the section was actually written in the 1790s, okay, 1790s by Jefferson and Madison, and it has not in any substantive way been amended since then. And they listed 4 categories of patentable subject matter that we want to give patents to. Of course, the Constitution says we can give patents to the useful arts. What does that mean? So in the first patent statutes in the 1790s, they gave 4 categories of useful arts: process, machine, manufacture, and composition of matter. Okay? Those categories have not changed since then.
Remarkably simplistic statute.
Yes, but it's worked quite well until recently. So if you think about it, it's absolutely remarkable that those folks back then came up with these 4 categories. They did not anticipate, obviously, DNA analysis. They didn't anticipate computer software. They didn't anticipate light, telephones. I mean, the whole thing, airplanes. Nevertheless, they managed to capture the system quite well for the next 250 years. But nevertheless, it has gotten quite complex since. So because the legislation hasn't addressed anything further on these 4 categories, the courts have. So the courts have interpreted further what these categories mean, and in particular, they've interpreted what they exclude. What is excluded from these 4 categories, and they have come up over the years with a number of exclusions, right? So they said natural phenomena, laws of nature, and abstract ideas, according to the courts, are exceptions to the 4 statutory categories. So that was going on quite smoothly until about 5 years ago, when the Supreme Court looked at this issue again, and in a series of cases, Bilski, Mayo, Alice, Myriad, in the past 5 years or so, have reinterpreted the exceptions. And from there, the lower courts have done a lot more, and it has caused recently quite a bit of confusion in the industry what this whole thing means. So because the legislation hasn't stepped in, we don't see the courts clarifying. Our examiners and judges deal with this issue day in and day out. Hundreds of thousands or millions of office actions every year, appeals and the like at the PTO. It's the number one issue that our employees deal with. So we have to do something about it across the board. So what we did is issue new guidance. Okay, so this new guidance cannot change the law, obviously. We must comply with the law, right? It's not our place to change the law. That's up to the legislation. Also, some judges think it's up to them. No further comment on that. But it's certainly not the administration's place to change the law. So what we need to do is administer the law. But we first need to understand it and administer it in a reasonable way and efficient way. So what we've done is to synthesize the cases because there's dozens upon dozens of one-on-one cases now. So we've tried to synthesize the cases. I do believe that the guidance is in full compliance with the law. We spent a year doing it approximately, and we paid very, very careful attention to the law. So I do think we're in full compliance with the law. On the practical application front of this, so before the practical application, so what we've done is we said, okay, what are the types of subject matter that the courts have found to be abstract? And we were able to categorize them in basically 3 categories of subject matter that is abstract. First, it's mathematical expressions by themselves. So just math by itself. Courts don't like math, apparently, so no patents on math. Second, certain ways of organizing human activity, like fundamental economic principles, escrow accounts, hedging transactions, and the like. And third, mental steps, things you do in your head. We're not going to have litigation over thinking. So those were the categories, and we said if you're not in one of these categories, there's no 101 problem. But if you do see something like that in one of these categories in the claim, for example, you see a mathematical equation in the claim, you don't stop there. If it is just a mathematical equation, then you have a problem and no patent on that. But if you do have a mathematical equation that is not just math by itself, but it is practically applied, it actually does something, then you're okay. Then that should be eligible. And I do think, long-winded answer to your question, but I do think that that is 100% in compliance with Supreme Court and Federal Circuit precedent. You go back a couple hundred years, the courts have always said, while we do not give patents on principles of nature, for example, we do give patents on the application of those principles. That's the whole point of the patent system. Human beings harnessing nature or harnessing mathematical concepts and the like, and applying them to useful ends. So if you're applying those, then you do get a patent on that. And many cases from going back to the 1800s to the present, and our guidance cites them and quotes them, find that practical application is the way out of these prohibited areas.
You know, I've likened the Supreme Court precedent in this area the last few years to them throwing a hand grenade under the tent and running away without basically, upsetting the system without providing any kind of guidance as far as where to go from there, and really left it to the Federal Circuit and, of course, to the Patent Office to try to pick up the pieces.
Yeah, although I should say that it's a good point. They did use some broad language. But I think a careful review of the Supreme Court cases, per se, does not necessarily did not have to lead to where we are today. Okay, so specifically, take the Alice case or the Bilski case, the 2 cases in the modern era on the so-called abstract idea. They both they don't deal with technology, right? Bilski is a hedging transaction. It's a way of transacting. It's a financial instrument. Alice is about an escrow account. It's me depositing money. I'm buying a house. I'm depositing money with an escrow officer, and you're depositing the deed. And then at the end of the day, we do the transaction like a basic escrow account. It's not about technology. It just happened in those cases that they did it on the computer platform. But the fundamental problem with those cases is that they were dealing with a fundamental economic principle, a financial instrument, and the court said, look, that's not these useful arts that was meant to be in the Constitution. So we didn't have to go from there to trying to think that all sorts of technology all of a sudden is subject to this exclusion. So I see some decisions that say things like, we have found that virus scanning is an abstract idea. When did the Supreme Court ever say that? Who has made the decision for the United States that we are not going to entertain patents on virus scanning technology? That's a technology. Now, it could be that the claim is not a good claim. It could be that the claim is so broad and so indefinite that you should reject it under 112, or you reject it under art because it's so broad and obvious, and you reject it under 102 or 103. That's okay. But it doesn't mean that the category per se, the subject matter, is ineligible. And the Supreme Court never really went that far. Similar on the bio side, right? You have a case like Mayo, where you're just observing, really without technology, you're observing a correlation between the level of a certain enzyme in your system, in a human system, and you're observing the correlation between that and the need to administer more or less of a particular enzyme. Not real technology involved in that. Compare that to a case where you're actually using technology, where you're labeling, for example, a molecule, and you're creating a brand new molecular tool completely made by humans that does not exist in nature, and you're using that to precipitate a particular compound and the like. That's very different. That's the whole point of the patent system, is to use technology to advance the state of human nature. So as soon as you're using technology, the patent system should come into play, and I don't think the Supreme Court has ever said something different.
It may end up being either, and I'm not sure whether it's a situation of bad facts making bad law, or just over-assessing, over-analyzing some of the Supreme Court precedent by the Federal Circuit and others to end up with the situation that we're in today. But certainly, you again, bad facts making bad law. You have the Sequin Arm Case, which, again, on the bio side, involved a cell-free fetal DNA, discovery of cell-free fetal DNA, and the allowed the possible use of that for prenatal testing in a way that had never been possible before. But the claims were, frankly, inartfully drafted and very, very broad for the most part. There were some minor exceptions. And the Federal Circuit obviously felt itself constrained. The Supreme Court ended up denying cert on it. It would have been an interesting case to have seen, but again, the overbreadth is the issue there, and in a lot of the cases, I think you're right, the Supreme Court's addressed.
That I was on the Ariosa side of that case.
Oh, were you really?
But that's, that case is somewhat closer to the Mayo case, where there is no real technology in the claims themselves, per se, than, let's say, last week's case, the Athena v. Mayo case from last week. So that went a step further. I don't know if it's bad facts making bad law. There is that, of course. There is also some of the broad language the Supreme Court has used in those cases. There is that, of course. But folks seem to have lost sight of Justice Thomas's careful statement in the Alice case itself, that you have to tread carefully here, because otherwise these exceptions can swallow the whole patent system. And unfortunately, I'm afraid that we have marched down that path. I cannot overemphasize how important this issue is. This issue was, patentable subject matter in Section 101 goes to the heart of the patent system because it tells you up front what are the areas of technology that the United States values for investment of time and money and for the future so that we reward and protect with a patent. And we are in a huge globally competitive competition. The competition for the technologies of the future is unlike what we've seen ever in the past. Everybody's innovating from the smallest countries to the largest countries, and some of those countries have gotten past this issue. And while we are twisting ourselves into a pretzel here on almost every case, and we don't have clarity as to what is and what is not patent eligible here, the other countries are marching full steam ahead to develop things like 5G, artificial intelligence, biotechnology. Some of the diagnostic techniques that here somehow have been found to be ineligible would certainly be eligible in Europe, China, Japan, for example. And I think that as a nation, we need to put this issue to bed ASAP so that we can compete on a global level.
There was that global economic IP survey that dropped the United States from first down to something like 12th in the 12th or 17th in the world, based in large part on the concern over and risk associated with patent eligibility issues in the United States. Did that raise any concerns in the administration?
It did, and I was asked about it during my some of my hearings in Congress. But yeah, definitely. So you're referring to the U.S. Chamber of Commerce annual survey done by their GIPC, Global Intellectual Property Center, annually. We were ranked number 1 for a number of years. Then we slipped to number 10, and then a year ago to number 12. And there were two main issues that there were some issues, but there were two main issues that they were concerned with. So one was 101 subject matter, and the second was IPRs. And we were tied for number 12 last year, tied for number 10 the year before. But this year, we climbed back to number 2. Just a couple of weeks ago, we are now tied for number 2.
Oh, who were we behind?
In large part because of the changes we've done to the post-grant system, IPRs and the like. Yeah. But they do note that the 101 issue is not solved yet, and that's why we're still tied for number 2.
Well, we're still Avis. Well, we're still Avis to number 1 Hertz, right?
Exactly, yeah. Exactly. We still have work to do.
Yeah. Who was number 1, by the way?
Singapore.
Yeah, they were
Past
number 1 last year too, right?
Number 1 last year. They're obviously a small country, but they're very innovative and they care a lot about their IP system, and they're working hard at it.
Now, coming back to the guidance, and by the way, the guidance is in the handout materials that we provided. There's a guidance, some examples, and then we included Director Iancu's speech before the Eastern District of Texas Bar Association, which I thought was very, very interesting. But with respect to the guidance, some of the questions that have been raised is whether it's intended primarily to cover the high-tech and other areas, business methods area in particular, but not really the life sciences side. Any care to comment on that?
Sure, but yeah, some folks have mentioned that, but it is meant to cover all of it. There's no question. There's no question that there's more focus in the guidance in this particular memo on the abstract idea side of things, because we wanted to categorize the abstract ideas, as I said, into the 3 categories that we have found in the cases. There is the 4th category, and the guidance mentions that there is absolutely the 4th category, which is the life sciences issue, natural phenomena and things like that. But we didn't see the need to do a further categorization of that. We believe, based on our experience at the PTO, that folks, our examiners and our judges can recognize fairly consistently if you see a natural phenomena in the claim. If you see DNA in the claim, you've recognized that. That's, something that you need to address. If you see, electromagnetism or some other natural phenomena, then you can recognize that. So we didn't think those needed categorization. Having said that, or further categorization, but having said that, the practical application aspect of it absolutely applies to that category as well, and the guidance says that. So if you see, for example, DNA in the claim, now you have to address it. So you have to ask, is it DNA by itself? Or if it is, then you have a 101 problem, because that's found in nature, without human intervention. Or is it a practical application of it? And if you're using technology, for example, in conjunction with this DNA, or you have a practical result from it and the like, then you've overcome the problem, and the guidance does address that. In conjunction with the guidance, we have trained all of our examiners. We issued 6 examples that are publicly available. By the way, all the training materials that we use for our examiners are available on our website, so you can, if you want to see what we use to train the examiners, you can look at that as well. But we've issued 6 examples, and the truth is none of them deal with life sciences in this first batch, but we will have examples on life sciences as well.
One of the questions I had was about consistency of application of this. Aside from the training materials and running the different groups through the training materials, is there anything else that is going to be done to try to assure consistency across groups?
Lots of training. So by now, the rollout of the guidance was timed to make sure that the day we roll it out, we can actually be ready and train the examiners. We have 8,500 of them, so we wanted to have all the materials prepared ahead of time. And in the first few days, weeks, basically within the first month, we trained all 8,500 examiners, with very few exceptions, and somebody was out sick or something. But they're basically, virtually all of them are trained. Same on the PTAB side, by the way. All our judges are trained. And there are different levels of training. You can imagine that some art units don't see 101 really all that often. Some don't see it at all. Whereas other art units, like cryptography, for example, they see it in every single case. So there are different depths of training for these folks, and it's ongoing. Keep in mind also that at the same time as 101 guidance, on the same day, we issued 112 guidance, right? Because we have noticed that some of the claims that have been caught up in the courts or even with the PTO on 101 should have actually, they did not really have a 101 problem, but certainly could have had a 112 problem. So we want to make sure that our examiners are consistently applying 112 as well. So we are in the process of training, really retraining on 112 as well.
Very good. With respect to the 101 guidance, there's been a few commentators who suggested that there's some pretty thinly veiled criticism of the Supreme Court jurisprudence and Federal Circuit jurisprudence in the guidance. Is that something that was intentional?
Look, the courts review the stuff that comes out of my office. So no, I don't think we were trying to criticize the courts. In all seriousness, it is a tough issue. It's really complex, especially in light of modern technology. It's a tough issue. What we were trying to do is synthesize the cases. And I have said publicly in a variety of speeches that one of the issues that has taken place, one of the problems that's led us down this path is the commingling of the statutes. Commingling of 101 with 103, 102, 112. And it wasn't meant as a criticism. It's meant as a, let's try to untangle these various issues. Because I think that we can drive a lot of clarity back into the system if we just untangle them. I'll give you an example. And this is a large reason why we promulgated both 101 and 112 guidance at the same exact time. A lot of courts, and also at the PTO, they see some claims that, especially on the computer software side, that are very high level and result-oriented, functionally drafted, right? Without telling you how to do it. It's just function and result. So, and very, very broad and so on. So courts and examiners naturally have a negative reaction against those, and they want to find a way to invalidate them. And there's nothing wrong with that if, in fact, they don't deserve a patent. But do it under the correct statutory basis. The whole point of the 1952 Patent Act, and in fact, the genius of the 1952 Patent Act, it was to categorize these exceptions, the reasons for patentability. So if a claim is functionally drafted and there is no support in the specification for how to achieve those functions, for example, well, you have 112 for that. It's in the statute. Yeah. If the claim is so broad that and so amorphous that it's indefinite, again, you have the definiteness requirement in Section 112. Also, you can be captured under prior art, under 102 and 103. Reject under those bases. Don't reject under 101. So really, not a criticism, but the way to untangle, and I think, look, we know how to do the various analyses under the various statutory categories. The problem is that we don't really know how to do the amorphous abstractness analysis under 101. That's the problem. If a claim is indefinite, we know how to do the definite analysis under 112. I'll give you another example. A lot of folks have been concerned about claims and want to reject claims, probably under 101, because it is the use of something old that's been done a lot in the past, but now it's done on a general purpose computer or on a computer, okay? So it's the combination of something that's been done in the past with a general purpose computer, that combination. And people find a 101 problem. But that's really difficult to do under 101. So if you take old technology and you automate it on a computer, how do you approach that 101 analysis? There are no guidelines. There's no test. But we really do have a good test that's been worked out for the past 50-some, 60-some years, actually, since 1952, under 103. We have the four-part, the gram factors and the like, the combination of old technology on an automated system. We know how to do that analysis. So do that. Now, reserve 101 for issues like Inalis and Bilski, for issues that are per se problematic, like fundamental economic principles. Reserve 101 for that, because for that alone, 103, 112, 102 might not suffice.
Thank you. I'd like to turn a little bit to the PETA proceedings, both patent appeals and IPRs, because obviously that's been, whether the AIA, a significant area of concern. It seems like the original concern of the PTAB being a hit squad for patents, I think, when
Death squad, I think.
Death squad, I'm sorry. That concern has changed a bit over time. As I understand it, the statistics have suggested that that's no longer quite so significant a problem. But has there been anything done within the last year or more while you've been director of patents to try to alter that even more? Let's put it that way. Balance the playing field a bit.
Yeah, so we did quite a few things over the past 12 months. We're still working on some things, so some of the things were, first, we changed the claim construction standard. We no longer do IPRs under the broadest reasonable interpretation standard. We're now using the same standard as it's used in the district courts and the ITC. I think that will go a long way towards increasing predictability and increasing the efficiency holistically for the patent system. More than 85% of the patents we have at the PTO in the IPR proceedings have parallel litigation. So it's odd that it was odd in my mind that we would have the patent meant different things. An actual issued patent meant different things depending on who looked at it. So anyway, so we've changed that through a rule change. We went through a notice and comment period, and anyway, so that was done last fall. We have issued a new trial practice guide that does a number of things, but one of the things it does is to add a bit more clarity about the institution decision. When is it appropriate, for example, or when might it be? When is it appropriate to deny institution because there have been other proceedings like it, and so on. We have issued new procedures for empaneling cases and for review of cases. So there was some criticism in the past, as you might know, about the opaqueness of our panels, and you might have heard folks talk about panel stacking. I don't know if that ever happened, but people were concerned about, the PTAB adding judges to a case to get a desired result. If they didn't like if the PTAB management apparently didn't like the result of the first 3 judges, there was this concept that we would add judges. Again, I really don't know that ever happened. But in any event, in order for full transparency, we changed the process. So we have a particular standard operating procedure that tells the public how precisely we panel judges and how, under what circumstances, we would change a judge. And now we basically eliminated the enlargement of panels. We're always going to have 3 judges. There might be narrow circumstances where we need to have more than 3 judges. For example, if there are several cases, several petitions on the same patent, and that's being distributed among different panels for workload, you might have to combine them at some point, but that's going to be very rare. So instead of that, we have created a presidential opinion panel. That includes the director, the chief patent judge, and the commissioner for patents. So if you're dissatisfied with the result of the 3 judge panel, you can seek review by this presidential opinion panel. So that hopefully can create more consistency at the PTAB. Let me just mention, sorry.
Oh, sorry.
One more change, apologies. One more change is the amendment process.
Yeah.
So we have issued a proposal a few months ago on how to improve the amendment process. That was open for public comment. I don't know if the Chicago IP Law Association submitted comments, but lots of people did. And we're reviewing those comments now, and we're likely to have a final notice coming out soon on the amendment process.
With respect to these things like the guidance and the proposal for amendments, when do they get implemented? Are they implemented at the time that the proposal comes out in some way, or does it wait for the public comment and then a final notice?
It depends. It depends on a variety of factors. So at the on the patent operations side, such as the guidance we just issued on Section 101, that was implemented the day it issued, and I think it was January 7th, if I recall correctly, something like that. On the PTAB side, for the claim construction change, we waited for the comments. We made changes in response to the comments to the claim construction notice. We waited for the final rule, and then we implemented actually on petitions filed after that. So the petitions that were already filed and are in process, they still get the old claim construction standard.
One of the things I'd heard was that there was a prediction that because of the change in the claim construction standard, which was viewed as being pro-patentee, that the Patent Office would be flooded with a bunch of petitions within the last month leading up to the implementation of the Phillips standard. Did that occur?
It did, actually. I don't know about flooded, but we did see an increase in the last week, especially the last day. More petitions were filed that week than any other week in the past, I don't know, year or so. But it kind of smoothed out. So if you accounted for the whole quarter, we had a few more petitions overall, but it's back to the normal levels.
With respect to the PTAB policy in connection with SAS, there was also a little bit of a concern. SAS was a Supreme Court decision that ended up really getting rid of the PTO practice of partial institutions, and with respect to that, the PTAB was required to consider all challenge bases in the petition. In implementing that, though, the PTAB actually went one step further and actually looked at not just all challenge claims, but all possible bases for all of the challenge claims. Probably a little further than the Supreme Court necessarily required the PTAB to go. Was that a procedure that involved a lot of deliberation by the PTAB? Did that come up to you, or was that done largely at the PTAB level?
It did involve deliberation. Post-SAS, we said we're gonna, if we institute at all, we're gonna institute on all the challenge claims and all the asserted bases. So not all possible bases, but all
asserted bases, right?
Bases asserted by the petitioner in the petition itself. I don't know that goes beyond what the Supreme Court has said in the SAS case. Depending how you read the SAS decision, a reading of it is that it should include all challenge bases. For example, the majority said that the petitioner is the master of the case, period, in terms of what issues are included and what not. So, but in any way, so that was a reading of the decision, and some would say, a safer reading of the decision. But more importantly, from a policy point of view, really, if you look at the system holistically, right, and again, more than 85% of our IPRs are involved in parallel litigation. A petitioner, when they file an IPR, chooses the IPR forum at that point. So, and the statute does say that IPRs and PGRs or whatever, the post-grant proceedings should be an alternative to district court litigation. So, if the petitioner chooses to have the dispute as they frame it, litigated in this forum at the PTAB, let's do it there, as opposed to the piecemeal type of an approach. And I think that's what the Supreme Court had in mind as well, and probably holistically for the system is more efficient.
One aspect.
It also addresses, sorry to interrupt, it also addresses it touches upon the issue of estoppel further on.
That's exactly what I was going to raise. The ironic result of the former practice by the PTAB was that only the best challenges, bases, and claims were subject to estoppel after the fact in district court litigation, whereas the lesser claims, the ones the PTAB found was less likely to be successful, were left alive for the challenger to reassert in litigation. So from that perspective, the new procedures by the PTAB seem to make a lot of sense. Yeah. There was also a concern that because of this new rule, the amount of workload would be so significant that it would lead to a lot of discretionary denials of institution by the PTAB. Has that come to pass?
So, it has resulted in increased workload. I don't know exactly how much, but a meaningful increase, both at the institution phase and also at the final written decision phase. What we can't tell yet is if it's going to change the number of petitions or the quality of petitions that come in the first place. So we'll see if overall it changes the workload, but on a per petition basis, it does increase the workload. And it does affect a little bit. There have been a couple of cases where it leads to the board deciding not to institute at all. So just as an example, if you file a petition on 20 claims with I don't know how many bases for invalidity, and the PTAB finds that 19 of the 20 claims are not likely to succeed. One claim is marginal, could succeed, might not succeed, whatever. They might exercise their discretion, looking at the whole issue holistically, not to institute. So that has happened, and it could happen.
Another concern over, or another possibility for discretionary refusals to institute are follow-on IPRs, ones where the later IPRs use substantially the same prior art as an earlier challenge, whether successful or not. Are there any plans for the PTAB to place any meaningful restraints on accepting such multiple challenges?
There's several issues packed into that question. So first of all, we have already in the trial practice guide from last summer included factors from the factors that address follow-on petitions basically by the same petitioner. They generally come from the general plastics case that we had at the PTAB, so some folks refer them to the general plastics factors. But they deal specifically with the same petitioner filing another petition at some point after the original petition. Perhaps after they see the institution decision. Maybe the institution decision denies institution, like in the example I just gave you. And there's still time for the petitioner. The 12 months haven't expired. There's still time for them to file. Those factors do deal with that issue. And to a large extent, we have significantly cut down on follow-on petitions by the same petitioner. You really have to have a good reason to have a follow-on petition and on the same patent by the same petitioner. There are other issues, though. What about other petitioners? Right? Obviously, if it's a petitioner in privity with you and you're working together, maybe the same analysis applies. But what if you're not in privity? What if you're co-defendants in a case but not really working together? Or there are parallel cases and you're not in the same case at all. Or maybe the second petitioner is not even sued yet, and for whatever reason they want to file a petition at some point. All sorts of questions like that. So we are working through that as well. And you will have, already you've seen a couple of decisions in some that touches on some of these issues. And it could be that we would deny institution on a follow-on petition by another petitioner, depending on a variety of factors. There is also a separate question about the same petitioner filing multiple petitions at the same time. I'm sure many people experience that here. We have page limits or word count limits, whatever. And some people think that they need to file multiple petitions, multiple bases for invalidity and the like. At some point, though, you have to ask how many petitions suffice on the same patent at the same time. If you don't like your first, second, or third ground of invalidity, for example, and you have to be into your seventh or eighth ground of invalidity, why is it in the interest of the United States to devote so much resources to address every single ground for invalidity? Some district courts, for example, make you pick your 10 best claims, for example, and things like that. There are other limits that we can impose on a discretionary basis. We are looking at that issue as well. And we might have something on that particular question as well. Bottom line is we want to give everybody a fair opportunity to be heard, but at the same time, we want to avoid multiple bites at the apple. We want to avoid overburdening the system as well.
Just a couple last questions. With respect to claim construction, clearly the PTAB's been instructed to take some more notice of what claim constructions have been rendered in district court, et cetera. Are there any situations you envision where the PTAB would not find a prior district court claim construction to be binding on the PTAB?
It depends on the stage of the district court litigation, right? At some point, right? If it's, for example, take an extreme case, final decision from the courts, including appeals exhausted and the like, and there's an affirmative finding on a particular term that could have a preclusive effect. But what if it's in parallel, right? What if the district court is still litigating, right? And it just issued a claim construction decision last month, for example. Obviously, it could change. We know that district judges sometimes change their claim construction decision, sometimes in the jury instructions at the very end of the case. So I think our judges are instructed to look at it, to consider it carefully. Nobody wants to duplicate work, and if the issues are fairly presented in a parallel case, we should obviously look at that very carefully and consider it. Sometimes the issues are not presented squarely. Sometimes different arguments are being made. Sometimes different evidence is being made of record. So I can foresee situations where you might have a different point of view from what the district court has done based on a variety of factors. But look, the overall goal, I think, for the U.S. patent system would be to be as efficient holistically as possible. And one of the reasons for using the same claim construction standard is so that we can achieve more efficiency, so that we at the PTO can look at what the courts have done and incorporate it if it makes sense. And likewise, for the courts to look at what we have done and not duplicate the efforts there if it makes sense for them. And I think this drives this rule change and everything else we're trying to do. The SAS case, by the way, likewise. It drives in that direction, and I think overall that's a good thing.
And, you know, talking about the efficiency and consistency component, I think you mentioned earlier that the PTAB's being trained on the 101 guidance and presumably the 112 guidance as well. Is it expected then that both in CBMs and in PTAB appeals that they'll be applying the same kind of 101 and 112 guidance that the examiners will be?
Yes, so the PTAB is part of the PTO, so they need to follow agency policy where it's required, and 101, so the PTAB judges, both on the ex parte side and the AIA side, CBMs, PGRs, and the like, they are following the 101 guidance that we have just issued.
Very good. Well, I want to thank you very much. I think our time is just about up, but I really appreciate you spending time here with us today.
Great. Thanks for the invitation. It's
Thank
great
you
to
very
be
much.
Here. Yep. Thank you. Great.
Thank you.
That's fine. Thanks. That's good.